So thank you, Andrew, and thank you to GLG for organising such a fantastic event in a superb location. And thank you to Portugal and our Portuguese hosts for laying on some sunshine. Those of us from the UK haven't seen it for about a month, so it's great to have it with us. So in this session, we're going to be looking at where product liability claims fit in the class actions landscape. And as lawyers like to do, I'll start with a definition. So for the purposes of this panel, what we're talking about with product liability is a broad scope. We're looking at issues faced by consumers from a product, and that includes the more obvious safety-related issues such as those from pharmaceutical products or medical devices, as well as misrepresentations about performance or quality, such as the vehicle emissions type claims. So we'll start with some introductions. If I can start at the far end, Matthew.
Bon dia. Good morning, everybody. My name is Matthew Angelus. I'm a partner at Torys in Montreal. Torys is a full-service Canadian law firm with offices across Canada and in New York in the US. My own practice is focused on product liability and consumer protection class action defense. I also do quite a bit of compliance work, helping companies generally who are outside of Quebec comply with our unique product standards regime and with our unique consumer protection regime as well, with a focus on class action avoidance.
Hal.
Hi, everyone. I'm Hal Singer. I'm an economist at Econ1, a managing director there. It's an economic consulting firm. I'm also a professor of economics at the University of Utah. And my practice spans a few different areas, antitrust and increasingly consumer protection. And recently, my reports have been cited by courts to certify 5 classes in consumer protection matters. And I think we'll talk about a few of those today.
Yeah, so I'm Mariana Soares David. I'm a partner at the Portuguese law firm Leitão and a member of the firm's dispute resolution team. I've specialized in the prevention, so I also do a bit of compliance and regulatory work, but mostly in resolution of disputes around the product value chain, so consumer protection, product liability, and distribution agreements. And throughout the years, I've assisted clients in class actions, product liability, civil and misdemeanor proceedings, actually, and also in implementing recall and withdrawal measures.
Thank you all. And as Andrew said, I'm Miles Robinson. I'm a partner at Mayor Brown's London office, specialising in complex commercial disputes. That's included defending group actions since the late 90s, particularly product safety and environmental damage matters. So let's kick off with some scoping questions first, before we get to some more philosophical questions, which might, we hope, spark some debate. Certainly amongst the panel, from our pre-sessions, I know it will, and hopefully from the audience as well. So let's talk briefly about the landscape for product-related actions in a couple of jurisdictions. So what legal basis are they brought under? What remedies are sought, and how common are they? And maybe some examples as well. So if I could start with you, Mariana, is that okay?
Sure. Yeah. Well, as you explained, product liability here will be seen in a very broad sense, but just yesterday, speaking with Matthew, we realized that the concept that is used for product liability is quite different from the EU landscape, comparing with Canada. So just for clarity purposes, to give you an idea of what two realities, and I'm of course oversimplifying, we can be speaking about when discussing product-related actions available to consumers. The differences lay mostly on the type of damages and on the type of remedy. So we can be speaking on the one hand of product liability stricto sensu, and that relates to the manufacturer's strict liability for placing unsafe products on the market. The example would be, or could be, a dishwashing machine that, as a consequence of an infringement of safety rules within its manufacturer, causes a fire and thereby causes damage in household appliances and perhaps physical damages to someone nearby. And in that situation, we would, at EU level, because it's quite harmonized at this point, the consumer would have the right to compensation for damages caused by the unsafe products in other products or in other people, so not the damage of the product itself, and this would occur within a 10 years period after he places the product on the market. And then we would have, again, oversimplifying, all sorts of consumer protection claims you can think about, mostly relating to delivery of a defective product, so a product that does not match the expected qualities given the contract, or from the infringement of other consumer rights, notably information rights. The remedies here will vary depending on the contractual or non-contractual nature of the claim, but essentially they can be brought against the seller or the manufacturer, and the most frequent would be the rights of repair, replacement, and compensation for damages. And with this in mind, just to give you an idea of the landscape and what has been occurring in Portugal, we have already seen in other panels that Portugal has been experiencing an increase in consumer class actions, so, and also product-related ones. Actually, if we think about the past year, we experienced a 240-ish% increase. Most of them have been filed by consumer associations. The claim are for injunction relief or compensatory relief or both. And well, I chose to just give you an idea of the most typical grounds on which they are based. So private enforcement of anti-competitive practices, non-conformity with the consumer's expectations, and this can also have to do with labeling and publicity, unlawful commercial practices, notably for lack of information on the product and its price, so promotional prices, beware of Black Fridays, lack of pre-contractual information, and more recently, and this is quite unique in Portugal, for the absence of an electronic complaints book made available to consumers even by online platforms. This is quite unique in the obligation of Portuguese law, and it's doubtful whether it applies to companies without a permanent establishment in Portugal. And just as a final note, although, well, the core of this discussion could be product liability in a narrow sense, we come to the conclusion that, at least for now, individual claims or joinder of individual claims have been the most usual form of proceeding in this sort of cases.
Okay, so let's, and we've heard a lot about Portugal as well, and we'll hear a little bit more, but it's really interesting that this is such a hotspot for all types of claims. Let's jump across the Atlantic. Matthew, Canada.
Right. So thanks. I'm from, as I mentioned before, I'm from Quebec, which is not only Canada's only primarily French language province, but it's also Canada's only civil law jurisdiction. It's also, as yesterday's keynote speaker alluded to, Canada's first jurisdiction which adopted a sort of a modern class action legislation in the late 1970s, and it's Canada's most plaintiff-friendly jurisdiction. Above the sort of narrow concept of product liability being the fault or the damage caused by a product to another person or their property, Quebec takes a very broad focus on what is a product liability claim. These usually take two forms, either in the consumer sense, where one is arguing that a product failed to meet a standard of fitness for purpose, or in a sort of a more general failure to disclose scenario, whether it's in advertising, whether it's in product disclosures, whether it's in labeling or otherwise. But there's also a possibility of claim on outside of the consumer's focus in a more sort of limited civil space, which is really a failure to maintain a minimum standard for the product. And that applies whether someone is a consumer or not. And an example of that would be a recent class action alleging underpowered engines in trucks and the various damages that result. A claim that, yes, there were some individual truck owners, but they were mostly fleet owners who were members of the group. In terms of the remedies that are sought, we see, again, in addition to the compensatory and even punitive damages for harm which is caused, the most common remedies sought are either annulment of the purchase or a termination of a service agreement relating to that purchase, but most importantly, the return of the purchase price or the reduction of the sales price. They can be, these remedies can be sought either on an individual recovery basis through a class action or on a collective recovery basis. The individual one would inevitably involve individual defendants, individual members proving their own claims, but and as we've seen over the last few days, relatively unique is the ability to actually have collective recovery where amounts are deposited directly into an account which already exists and which the information is already there without the consumer having to do, frankly, anything. And may not, other than the notice requirements which they saw, may not otherwise be aware of the case and just have a surprise payment arrive in their account. In terms of injunctive relief, it is possible, and the courts, Quebec courts constantly remind parties that yes, it is possible to seek an injunction through a class action, but practically speaking, it's not a very useful remedy. The cases take so long to work their way through the courts that in order for someone to seek an injunctive remedy such as repairing a product, by the time the case is ultimately finalized, the remedy is often theoretical. The product is either no longer in the hands of the purchaser, has been sold, it has been simply replaced for a long time, and people are generally better served with damages.
Thanks, Mariana and Matthew. I think that's a really good scoping briefing. I think next or final scoping question before we get into some more technical aspects and some philosophical aspects, just in terms of whether you're seeing a rise in these types of claims, and if so, why? So I'll start with you, Matthew.
In terms of a rise, I'd say that the number of claims has been relatively constant over the last 5 years or so. They really peaked around the time of the pandemic. We've seen the number of roughly 100 class actions in Quebec filed a year be as a relatively constant figure. In the rest of Canada, you see generally 2 times that, but spread out across jurisdictions. There's more focus in BC, less in Ontario. But I'd say that the number has been relatively stabilized. We have a very mature class action market, and so I wouldn't say that there's been an increase over the last 5 years.
Okay. Do you want to talk a little bit about the legal minimum standards for goods and whether that's a particular factor?
Sure, and bear with me for one last technical jargon before we can actually get into a little bit of a discussion. But I think it's helpful to understand as we look at the different regimes. It's easy to talk about what's similar, but I think it's a little bit more interesting to talk about what's different. In addition to the procedural elements which I described earlier, Quebec does impose on the sale of goods a legal warranty of quality, which is a minimum standard for every good sold, which holds that it must be fit for its intended use and durable for a reasonable amount of time, and that is really based on the price which is paid. So there's 2 elements to that. A deck of cards might only need to have a certain minimum standard of duration of a week. A furnace, it might be 30 years, and there is case law regarding the duration of the furnace, but it also has relation to price paid. So a Bic pen has to have a longer shelf life than a Mont Blanc. I think that one other important element to mention, and something that sets Quebec apart, is a triple presumption of liability, which works against the professional seller. So once a purchaser has established that a good has failed for whatever reason, prematurely when compared to other goods of the same nature and of the same price, a triple presumption is immediately invoked, which has 3 heads. The first is the existence of a defect. The second is that the defect predates the sale of the contract. And finally, a causal link between any damages suffered with the malfunction itself. Now, while this is a rebuttable presumption, it has the effect of transferring the burden of proof from the claimant onto the defendant to prove that their good was in fact was exempt of any defects. And this, in the class action space, is an incredibly strong tool for plaintiffs who we're seeing more recently are not even filing expert reports on liability and are relying on the triple presumption to say, hey, defendants, show us that your products are actually functional. While this presumption works in terms of showing the defect, it does not show damages. And we've seen in a number of cases, and I have one in mind against Mazda alleging a failure of the lock mechanism on the car that was taken on behalf of 2 groups. The first, if the lock failed and the car was stolen, Well, that was relatively easy to prove damages based on the present market value of the vehicle. But there was a second group that was seeking damages based on the law, who did not have their car stolen, based on the perceived lack of resale value for those vehicles. And they tried with various ways to adduce evidence into what are the actual damages that were suffered. They tried doing it with a survey, and you had a bunch of different members saying, oh, my car is worth less, $1,000 less. My car is worth $3,000 less. Ultimately, a court found that while, yes, there was the defect was proven based on the presumption, ultimately that damages were not, and awarded a zero damage award after 14 years of litigation.
So, well, so I follow that, Mariana. And anything in Portugal that you want to add in terms of what's driving rising cases?
Well, we haven't had that many class actions really, well, in a narrow sense, for product liability, so more about individual or group claims, jointer of individual claims. But while we have had a boom of class actions, so consumer-related, so product-related consumer class actions, mostly with the kind of cause of actions I mentioned, well, and we could discuss the reason for that, and I would say that in all jurisdictions, individuals are more and more informed, but this is not particular for Portugal. We could say that we have a very claimant-friendly system, but, well, we have this since 1995. So I would say that the main driver are actually the new, increasingly sophisticated consumer associations backed up by funders and also very specialized law firms.
Okay, thank you. And we'll talk a little bit more about funders and drivers in a bit. Now, Hal has been unusually quiet. Longest I've heard him.
I did have a comment.
For a while.
I did have a comment on something you said, though. If I understood right, you didn't have to use an economist to get the class certified?
No.
That's terrible.
In
That's
fact,
we should.
you never see economists at the certification or authorization stage.
And we don't even have a certification
We should write that
stage,
right into the statute. You have to have an.
No, that's a great segue into certifications. Hal, do you want to talk a little bit about that? And I think we have. You're not the only one who has slides, but you're the second one who has slides. So here you go.
Yeah, and I apologize in advance for making a very short slide deck, but I wanted to talk to you about the methodology that I've been using in my consumer protection cases, product liability cases. With some success, I've mentioned at the top, we've had 5 classes certified around my impact models, and they all turn on these conjoint studies. And just to kind of tick through the cases, if you guys want to go check them out, very good opinions here, but it's in Juul, the smokeless cigarette product marketing case, MacBook keyboard defect case, and then there's 3 COVID education cases, Pepperdine, USC, and LSU, although LSU was overturned recently in an appellate court, but I still count that as a class that was certified around a Singer report. But what I wanted to show you is, okay, I'll look up there, but they're all around. I thought it'd just be easier to kind of show you just a few screen grabs of the survey that I used in the MacBook keyboard defect case. Just by way, quick background, the allegation is that the keyboard was prone to be sticky and to otherwise fail, and it turned out that 8% of owners who purchased this type of MacBook suffered the keyboard defect. So it was about 8% failure rate. So that made things tricky for what kind of discount a consumer would have demanded at the time that they purchased the keyboard had they understood that it was subject to this defect, right? It's a probabilistic thing. So on our first time through, we want to make sure that we're getting people in the survey who kind of fit the target audience. So we're going to ask you, have you ever bought one of these keyboard types before? And if you haven't, you don't make it through the filter. You don't make it through to the survey. We want to make sure that we're targeting the actual types of customers who buy, in this case, a MacBook, a computer. You can flip it. I promise to go quickly through these. Now, in this one, the first time through, we decided that we would tell the user that if they saw in their choice screen one of these computers that were subject to the defect, it would happen with 100% probability. We did that because we thought that consumers taking a survey would have a hard time internalizing and processing what an 8% failure rate meant. So the first time through, we wanted them to assume it would manifest itself with 100%, and then whatever discount they demanded on the price, we would discount that by the probability that it failed by 8%. That was the first time through. So this is one of the screener questions. It kind of prepares the reader for what they're seeing when they get taken through the survey. So that's that one. The last one, I promise, I think. Maybe we have two more, sorry. But this is kind of the attributes that we're going to put into our survey. And of course, you have to have the price in any kind of conjoint survey in order to solve for a discount that the consumer would demand in order to be made whole. And then I think we have some decoy defects. It's very hard for me to read what's up there, but we wanted to kind of give the reader an impression of what's going to come next in the survey. So you guys can flip, and I'll show you what a sample choice screen would look like. And so each respondent who goes through this is going to get 10 of these screens, 10 choice sets. And you always have the option of, no, I don't want to choose any of those things. But so here's option A is MacBook Pro with a certain price. And you can kind of see, I don't know if it's too small for you, but you can see, when it is and isn't subject to the defect. And so what we want consumers basically to reveal to us through their preferences what their distaste is for the defect in dollar terms. It's a little different than the survey you mentioned before about just asking someone, what kind of thing that they would demand. Economists and statisticians recognize that that's not a sound approach, because the respondent might know that they could game the system by demanding a really, really high discount to be compensated. So what the conjoint is doing is instead allowing their choices to reveal what their discounts are. I think that's the last one. Oh, so the results. What we found was that we were able to get a $650, I think, discount from that survey if they thought that it was going to fail with certainty, and then we discounted that by 8%, the probability rate. And the only thing that I wanted to say, and I'll wrap up here, is that Apple, of course, hired its own experts to combat me. And they thought that the 8% really, really needed to be put into the survey. And so we said, fine. So we actually went back out and redid a survey with the 8%. And it turns out damages got even bigger when we did that. But I think I'll turn over the mic. We agreed ex ante to, as part of our cartel, a 3-minute talking rule. So the first conspiracy I've ever joined.
And you infringed it.
And I put me in jail.
So I will ask you another question, actually, Hal. I mean, as you will have gathered, three of us are primarily on the defendant side of the fence. Hal is perhaps more on the claimant side. You've talked a little bit about what opposing economists said in the Apple case. What more generally, what sort of advice would you give to lawyers who are choosing economists in these types of cases? What are the sort of key things that you would expect them to be asking?
Yeah, I think that, of course, we want to know what's your experience in these cases before. It's kind of a gatekeeper, but I want to know, have you ever used a conjoint in practice in prior litigation? How did it turn out? Have you ever written about conjoint in an academic setting? That would be a nice plus for an expert. But I think that in my exposure, and I'm just talking with other people in consumer protection cases, product liability cases, it seems like conjoint is the most popular model to go with. The other tool in the economist toolkit is regression. Now there is a regression going on in the background to solve for the required discount. I didn't want to kill you guys with that, but traditional regression that economists use is really out the window. We really don't have the opportunity to use a regression. So conjoint is the key. So I'd want to know, what experience do you have in conjoint, written, testifying? How did the judge like it?
And you're clearly favouring the conjoint model, but is there a lot of pushback to that, or do you think that's pretty solid now?
I haven't experienced in the 5 cases that I mentioned, I haven't experienced someone saying that conjoint couldn't be used for it, right? That's not really the fight. The fight is the implementation of the conjoint. Did you get the right sample? Did you lead them astray with any screener questions? Did you include the right decoy attributes? Stuff of that nature.
Okay, thank you. So I'm going to go slightly more philosophical here. In terms of what's behind these kind of actions, is it funders? Is it consumer associations? Is it claimant firms? Is it even claimants? And who really benefits from these types of actions? And I suspect Hal might have a slightly different view from some of us, but maybe not. We'll see. I'll go to the end of the line first of all.
Yeah, I think that at least from my experience, not only are the claims primarily plaintiff counsel driven, but in many cases the primary benefit ultimately goes to plaintiff's counsel. Where I practice, the general rule, and there's been a little bit of pushback over the last, frankly, year and a half, is that at the end of the day, the plaintiff's counsel will receive a 30% envelope of the total settlement value or of the total judgment amount, which is a very big incentive to quickly settling cases, to launching and settling cases as frequently as possible. We also are in an environment where there are very low barriers to entry. It's basically a no adverse cost regime. Whatever adverse costs are very, very low in the 4 figures. And there is a public funded element to it that advances fees for the purpose of the claimant's fees and costs throughout the proceedings. Which means there's very little downside and a very big pot of gold at the end for plaintiff's counsel.
So plaintiff's counsel is the answer from the far end. I'm going to go to Mariana now.
Thank you, because I know what Hal's going to say. So, sorry for that. In Portugal, we have actually no tradition for funding with law firms, so upon contingency fees. So the driving is expected to be and continue to be on funders and consumer associations. I probably do have a bias being a defendant lawyer, but for me it is quite uncertain who actually benefits from these class actions. Consumers should be benefiting, but my biased opinion is that most of the times consumer associations and funders are the ones that are benefiting, especially because of the way the distribution of the awarded amount is made under Portuguese law. Because we will have a certain deadline for consumers to claim their share, and it is expected that most of them won't claim their share because we have an opt-out system and a fairly poor summoning procedure. So most of them don't actually know they're being a part of the proceeding, and if they don't claim a significant part of the share, what happens next with the unclaimed amount is that first, the claimant's costs will be paid and the funder fees also, with limited control from the court. So we in Portugal like very broad concepts, and the concept here used was a fair and proportionate amount considering the features and the risks, so it gives a lot of room. And then the rest goes to the Portuguese state, notably for the promotion of other class actions. So I'm not entirely sure if consumers are the one benefiting.
Yeah, interesting. Hal, I'll turn the floor over to you for
the truth. No, it's hard for me to understand how consumers can't benefit in the wins, right? If there's a settlement and it's a good settlement, and even if the plaintiff's attorneys keep 30%, it seems like that's a win by consumers. And of course, the plaintiff attorneys don't get paid unless there's a settlement, and that typically doesn't happen until after you get the class certified, which is hard. And so they're being rewarded for the risks they're taking, including the out-of-pocket for the experts that they have to hire. So I'm going to give the answer: the defense counsel is the beneficiary of the regime. They make money whether they win or they lose. They bill by the hour.
Not always.
Yeah,
No.
I'd push back on that. Only in terms of the point on the difficulty of certification. In the example I gave, I live in a jurisdiction where 75% of cases are certified, and with very low barriers to entry, which ultimately means those cases do get settled. And while it's true that they're only being paid, that plaintiff's counsel needs to be successful, of those 75% of cases that are certified, the vast majority, well above 95%, get settled before trial.
I'd also like to challenge that, but for different reasons. First, because of this particular feature of the Portuguese law, where consumers don't actually know they're being represented, so sometimes they don't claim their share of the settlement or of the award, but also because under Portuguese law, regardless of the amount you actually claim, and you can be claiming a million amount in compensation, the procedural the notional amount of the procedure will be 60,000 euros. So, and sometimes the claimant doesn't actually frame the claim in terms of the exact amount they want. It will be for further stage to be defined. And it's this to explain that sometimes clients don't actually have a real perception of the financial risk at stake. And so it's quite difficult to apply high rates in these sort of cases.
So thinking about the defendant's perspective, I suppose the sort of manufacturer perspective, and again, this is not particularly a legal question, and more of a philosophical question. Do these class actions improve product safety? So is there a sort of benefit in that sense to consumers, or do they actually have the effect of stifling innovation because of fear? So maybe, Hal, do you want to take that one?
Well, I would think that relative to a world where you could get away with anything, I would hope that this would incentivize firms to take more caution with respect to product safety, right? The problem is that proving that would be difficult because you'd need to experiment. You need an experiment, right, where you could toggle from a regime of protection to no protection and then see what happens to safety. But I think as an economist, my prior would be that relative to the jungle, that if a firm knew that it would be exposed to liability for making a defective product, it's going to make the products better. And that's a good thing.
But in terms of motivation for the business, I mean, are they not motivated to make sure that their products are safe and well received by consumers?
If they thought they could get away with it, my concern would be they would cut corners and consumers would suffer as a result.
Interesting. But Matthew, you're shaking your head quite vigorously.
Well, I would certainly say that class actions have impacted the landscape. I don't think, to Hal's point, I don't think you could ever toggle that scenario. It's the environment we see with very easily authorized class actions or certified class actions is one that certainly has legal departments, especially internal departments, but external as well, operating the function as sort of Dr. No, as saying, no, this innovation is maybe not quite compliant with the letter of regulations which might be 30 or 40 years old, and it's especially true in highly regulated spaces. And these spaces tend to have a very active government regulator as well. And so it's not true that the absence of a class action space would yield a Wild West scenario where industry action is functioning unimpeded.
Mariana.
Yeah, I would agree with Matthew also, because we have seen at EU level an increase of legislation of all sorts of, new safety requirements, among other things, and usually they follow with misdemeanor proceedings, so I'm not entirely sure that class actions are the only or the potential way to, or the more favorable way to increase product safety, although, of course, they keep companies in line, but well.
Yeah, and I think from my perspective, there is as a consumer, as we all are, there is a difference between wanting compensation and wanting a change of behaviour or wanting bad behaviour to be punished, and depending on the size of the issue, the size of the claim, I definitely, if it's a smaller claim, consumers will be less interested, I think, in the money side of it, but more interested in change of behaviour. So my perspective. But I mean, is there a better way, do you think?
Well, can I just respond to something? But I just want you to be sensitive that, I mean, one alternative is public enforcement, right? If not private enforcement, then public enforcement. But, and I hope they let me back into the country today after I say this. But, we have a party that doesn't want to enforce certain laws, particularly as they relate to consumer protection. So, I mean, who's going to be the enforcer then? And that happens every 4 years, right? And And then even if you have a party that's inclined to protect consumers, they're limited by their resources, so they can't be prosecuting every case that comes under the sun. So I think the private enforcement does fill a nice gap that would otherwise exist and would be colossal every 4 years.
And what about some sort of mix and match approach where you have some kind of judicial intervention, but then a sort of compensation scheme to pick up consumers rather than them having to go through the courts? Mariana, what do you think about that? Do you think that would work in Portugal or more widely?
Yeah, I would. Well, and again, with my bias against class actions, as they are frequently framed, I would actually feel that any sort of alternative path could have a stronger role. And I do feel that, well, I've touched base with the misdemeanor proceedings, and I do feel that there we often have a more serious approach to breaches of safety.
Yeah, okay. But Matthew, what do you think about that option?
I think that option is interesting, and I think that the only thing that I would add is there are different regimes that can exist. For example, a public insurer model. We have it with respect to extended warranties on these same goods, where the amount of the benefit is kept in trust for a certain period of time, and it avoids the judicialization of these proceedings on a macro scale, which goes beyond the individual harm.
Okay, so moving away from the philosophical aspects of this, quick question before we turn over to the floor. A couple of quick questions. One, what advice would you give to a business facing a product liability group action? Mariana.
Yeah, well, the first is to as a defendant lawyer, to engage legal counsel as early as possible. But then, and this has to do with the upcoming new product liability directive, the need to collect and preserve evidence, safety reports from the start, to prepare a solid legal and reputational defense, and almost always involve PR and technical experts from the start, consider settlement options, of course, and ponder counter-attack measures. Well, again, I'm referring to the Portuguese landscape, notably for bad faith litigation requests. I obviously know that some class actions are real and they're solid, but some aren't, and clients must have the opportunity to challenge them in some sort of way.
Great. And Matthew, anything else?
I just add to, I think it's important to take to use the opening stages of a proceeding as an inflection point. If there is liability, and there are cases where there is that liability, it's a good occasion to try to end the case quickly through settlement. But if you believe genuinely that your product is good, that if your product is free of defect, fight it out. If every case settles, there's a massive incentive to take every minor irritants and turn it into a class action. But by fighting it out, and actually winning, and there are examples where just by taking it out, if you believe in your product, defend your product.
So I'll move to the future now. Again, quick fire answers, please. Mm-hmm. What do you think is going to be happening in 5 years' time in this area? More or less activity? How?
It's hard to say more or less. I don't know if I have a strong feeling about that. It seems like, well, and I can speak to the jurisdictions where I play, but it seems like it's pretty strong right now. So I don't know how it could get stronger. How about just sideways? Yeah. Also, you didn't let me agree. I like this answer too. By the way, fight it out. Don't settle. I like that. That's very good advice. Same advice I would give. Certainly don't settle until after the class certification decision.
Matthew?
I'd agree. I'd say sideways. If you're in a mature class action environment, I don't think there are going to be more product liability class actions, but I don't think there will be less either.
Mariana, I'll finish with you on that question, and perhaps, in terms of legislative changes, across Europe? Do you think that's going to drive change?
I actually do. So I would disagree with both of you. I would assume that we still have room for, well, I'm not sure if this is good or bad, but we still have room for more class actions, even regarding different causes of action. So the RAD directive actually contains an annex with different possibilities of causes of action, and we haven't, well, claimants haven't explored all of them. I think we will continue to have, the EU is really good at making new rules, so we will continue to have much more legislation for that. We will have increasingly complex products, and I would just like point out what I think will be, well, we can have a lot of AI-related class actions, ESG also related class actions when referring to product. It's the scope of our panel. And finally, I would point out the new EU regulation on product safety, which will come in force December this year, and the new product liability directive, because both of them, as the Omnibus Directive, intend to include in the concept of product software and other digital products. And well, the system itself is much more claimant friendly, including a lot of rebuttable presumptions also, and disclosure requests, which are not that usual under Portuguese legal framework.
Okay, interesting. So no agreement across the panel whatsoever. Excellent. I think looking at the time, we've got about 5 minutes left. So I've got a couple more questions that I can ask you, but I prefer to open it up to the floor.
Yeah. Mm-hmm.
Yeah, thanks so much. This has been a great panel so far. I was just going to say a couple things. One was that, you know, I heard that in Canada, or at least in your jurisdiction, 70% are certified of class claims in products cases, and it's nothing like that in the U.S. You know, certification is much more rigorous. There have been some U.S. Supreme Court cases that have reined that in and made it much, much harder. So to the extent that there's sort of a Wild West in some jurisdictions, that's certainly not the case in the U.S. now. I was also going to say that, you know, regarding, you know, the moderator, you had said that, you know, maybe just injunctive relief rather than damages because the consumer is interested more in a change in behavior. But if the only downside that a company might see is to having to change their behavior if they're sued, and then it goes to class certification, and then it goes to the merits, and then they lose, is to make the change that they probably should have made in the first place. There's nothing like feeling a sting of, you know, a aggregate damages award to actually change that behavior going forward. So that's been what we've seen in the U.S. So I was just going to make those couple of points.
Nice.
Yeah, I mean, I'll just respond to that briefly. I mean, I think you probably need both, don't you? I mean, in terms of motivations for consumers, getting $10 back or $20 back is probably not a huge motivator. If it's a much bigger issue, then the compensation becomes a bigger motivator. But I think you need both aspects to drive a change in behavior.
Yeah, and I was just going to agree with that. I mean, we had seen some cases involving Roundup in the U.S., for instance, where, you know, the consumer class case settled for a large amount, but it was only $10 or $20 per consumer. Probably none of them really cared that much about it, but the damage to society of allowing carcinogens to go out into society, we saw in some of the individual PI cases, which ended up in, you know, tens of millions or billions of dollars of damages awards. So the consumer class cases kind of go in conjunction with that. Any individual might not care that much about it, but to society, it's a huge, huge problem.
I needed him up here on the panel to help me.
A wingman.
I have a question about the average span of litigation in Canada and Lisbon, because Matt, you mentioned earlier that there was litigation that lasted about 14 years, and then there was an unfavorable judgment. Mm-hmm. I suspect that's not the average, but if you could share that.
The average duration is quite long for merits-based cases. For the certification, or what we call authorization stage, that can usually be done in a year, just a little over a year on average. But the merits then become quite long. There are some cases that can go to trial in 2, 3, 4 years, but there are others that go 10 or more.
Well, for Portugal, the official statistics actually say that we can have a first instance decision within 2 years. We have a lot of cases that go way above that. But actually, I've had, like, as we've seen yesterday, most of these consumer class actions in Portugal are still pending, so the big ones. So we actually don't know how it will go. I can tell you that if it entails expert evidence, you can be speaking about 1 additional year, but I actually have a very favorable case. It was an environmental class action with 110 witnesses, and it was decided in first instance in 1.5 years. So.
Right. Any more questions? Yeah. Okay. Well, it just remains for me to.
I think there's one more question.
All right.
Oh, sorry.
Thank you so much. Tracy Cowan. So I have a question for Hal. I am handling some product liability claims in the fertility market space. And these are not direct purchaser claims, right? Because they have to do with devices that are utilized by fertility clinics in providing services for fertility patients. And I just wonder how you would conceive, or if you think a conjoint would be helpful in that case where it's not really analyzing what the client would pay, right? Because they're not paying for the individual device. But how would you utilize a conjoint in that sort of a situation?
I'm struggling with that too, because I've got some drug cases right now, product liability, where the patient really isn't exposed to the full price of the drug. It's covered by insurers or other intermediaries. Mm-hmm. And the question is, can we still use a conjoint on the consumer to get at the discount that, in your case, the woman would have demanded had she understood the risk at the point of purchase?
Yes, exactly.
Yeah, I mean, the question is, if her opinion doesn't matter, then whose does? Like, who would matter more than her, right? It seems. I don't know why some insurance. I guess you could try to point your conjoint at insurance companies, but that would be the only alternative. I mean, it's just one other purchaser up the stream, but it's a tough one, and I expect some fierce battles coming down. If I had any hair left, I'd probably lose some more.
I appreciate that. Thanks. We've done one other one, and we used regression analysis, but it's a conjoint. I think would be very, convincing, as I found your presentation convincing. Some of the defense-minded people may feel less that way, but yeah, it's an interesting question.
Oh, thanks.
I think we're out of time, so thank you very much to the panel. Thank you to the organisers. It's been a pleasure.